I thank the member for his contribution. The question before the chair is that the amendment be agreed to. I give the call to the Parliamentary Secretary for Communication.
Thank you, Mr Deputy Speaker. I'm pleased to rise to speak on the Telecommunications Interception and Access Amendment Data Retention Bill 2014, a bill which amends the Telecommunications Interception and Access Act and the Telecommunications Act, and contains a package of reforms to ensure the continuing investigative capabilities of Australia's law enforcement and national security agencies. Now, this bill has generated a fair amount of community debate, and in the time available to me, I'd like to make 3 points. Firstly, I'd like to emphasise what this bill is not about. Secondly, I'd like to cover what the bill does do. And thirdly, I'd like to respond to some of the concerns that have been raised as part of the debate and address the measures that are included in response to those concerns. So let me come firstly to the question of what this bill does not do. And I should say that I bring to this debate a perspective having worked in these areas for quite a number of years. In a previous life, I was Director of Corporate and Regulatory Affairs at Optus, the second largest telecommunications company in Australia, and dealt regularly with the kind of matters that this bill addresses. At Optus, as is the case at the other large telecommunications companies, there's a law enforcement liaison unit which deals regularly with state and federal police and other agencies in relation to requests under the Telecommunications Interception Act for information and for content, in each case compliant with the various requirements under that Act. I want to emphasise that this bill does not provide law enforcement organisations and security agencies such as ASIO and the Australian Federal Police with new powers to access metadata. The powers that they have to access metadata are set out in the Telecommunications Interception and Access Act 1979, particularly Division 4 of Chapter 4. So there are no new powers to access metadata granted by this bill, nor does the bill expand on the range of telecommunications metadata which the police and security agencies are able to access. Again, that is not something which is contained in this bill. And indeed, I want to highlight just briefly some of the points made in the report of the Parliamentary Joint Committee on Intelligence and Security about the existing law in relation to the access by police and security agencies to metadata. And the report highlights the point that I've just made, that today's so-called enforcement agencies, as well as ASIO, are permitted to access telecommunications data under an internal authorisation which is issued under Part 4-1 of the Telecommunications Interception and Access Act. And I hasten to add that enforcement agencies are defined to include the Australian Federal Police, State Police and a range of other agencies, which includes various state crime commissions and so on. Now, as to what telecommunications data includes, under the existing terminology of the existing Act, before I come to the bill, telecommunications data includes such matters as the time, date and duration of the communication, the identifiers of the services and devices involved, certain information about the location of the respective devices, such as, for example, which mobile base station a mobile phone was connected to, and information about the parties to the communication, such as their name, address, contact details, billing and transaction information and so on. Now, I want to just emphasise again, I'm speaking here about the current law which is contained in the Telecommunications Interception and Access Act 1979. So this is law which has been in place for many years, and it's worth bearing that in mind when you consider some of the things that are being said in this debate about what people are concerned that the bill before the House today may do, because a number of the comments that are made appear to be made in a lack of knowledge of what the law presently says on this matter and has said for many, many years. I also want to emphasise that this bill does not deal with the content of a communication. It deals with information about a communication the term we've all now come to know and love, metadata, or what was referred to in the existing legislation as telecommunications data. So I do want to make it clear that there is nothing new in this bill in relation to the scope of metadata, and indeed, as I'll come to, in some ways, in fact, the scope is narrowed. And I again want to emphasise that the bill does not change the grounds on which metadata can be obtained by law enforcement agencies and security agencies. And I also want to make the point that large amounts of this data are today stored by the telecommunications company and internet service providers for their own business purposes. Let me make this point. In the day-to-day operation of a telecommunications network, enormous amounts of information are generated as part of its operation. So, for example, each time a mobile phone is connected to a particular base station, that is a piece of information. Now, that information may be kept for some time, it may be kept for a very short period of time, but it is information that is generated in the ordinary operation of a telecommunications network, and so is many other kinds of information which is generated and retained, for example, for billing purposes. So all of this is done for the ordinary operational purposes of running a telecommunications network. Now, let me turn secondly to the question of what it is that this bill does do. And this bill deals with specific categories of metadata, that's to say certain classes of information about telephone calls and so on. And the primary purpose of this bill, let's be very clear and specific on this, because again there's been a lot of confusion in the commentary. The primary purpose of this bill is to standardise the approach for how long metadata is retained. Let me make this point, Mr Deputy Speaker. Today, the law says, as I've sought to explain, that the security agencies and police, if they comply with the processes set out in the Telecommunications Interception and Access Act, can obtain metadata from telecommunications companies and internet service providers. That is not information about the content, for example, of a telecommunications call, but certain information in relation to the call. Name of the A party, name of the B party, time of the call, duration of the call, and so on. The law as it stands today gives those powers, but that it does not impose any particular requirement on the telecommunications companies and internet service providers as to the length of time for which they retain that data. And that is what is new about this bill. That is the essence of the bill before the House today, that it will impose on the telecommunications companies and internet service providers an obligation which they hitherto have not faced to retain these classes of metadata specified in the bill for a period of 2 years. So we need to be very clear what it is this bill does do and what it doesn't do, because a lot of the commentary, a lot of the public commentary about the effect of this bill misunderstands that fundamental point. Now, if we come to the policy intention behind imposing this obligation, this new obligation on telecommunications companies and internet service providers, it is firstly that metadata is a vital investigative tool, and many speakers before me have quoted the statistics as to the very high proportion of particular kinds of investigations in which telecommunications data is used, for example, in 87% of child protection investigations. But at the moment, the position is that the success or failure of a particular investigation by the police or the security agencies can depend upon a random factor, that is to say, which telecommunications carrier or internet service provider happened to provide the service which was used by the person of interest to the police or to the security agencies, and in turn, what are the particular business practices of that company with regard to the retention of metadata. So at the moment, the success or failure of an investigation, which could well be an investigation into a matter that goes to the physical safety and security of Australians, large numbers of Australians, depending upon the nature of the threat which is being investigated. The success or failure of that investigation today can depend upon the random outcome of which particular network is used and the particular business practices of the relevant telecommunications company or internet service provider. It is a desire to systematise the retention requirements, which is the policy, purpose and intent of this bill, and it is very important to be clear that that is what this bill does. It does not, for example, change the law as to the circumstances in which metadata is authorised to be obtained by the police or by the security agencies. Let me turn lastly to some of the concerns that have been raised and the ways in which the bill before the House seeks to address those concerns. Now, I note that the Parliamentary Joint Committee on Intelligence and Security conducted a very detailed examination of the bill and presented its report on the 27th of February. The government said that we would carefully consider recommendations made by the committee. The report makes 39 recommendations, including the recommendation that the Parliament should pass the bill, and the government has supported all of the committee's recommendations. Now, the recommendations in the committee's report focus largely on specifying the data set in the primary legislation instead of regulations, and specifying the agencies in the primary legislation instead of regulations, and increasing oversight mechanisms and privacy protections. And the government agrees that the bill should be amended to include the proposed data set in primary legislation, and also agrees that enforcement agencies be specifically listed in the legislation. The bill will also implement additional oversights for the new data retention regime, and particularly will significantly reduce the number of agencies that are permitted to access metadata. So the point I want to make to the House this afternoon, Mr Deputy Speaker, is that if you listen to some of the commentary, you might think that this bill creates new powers for information to be accessed and that it greatly widens the scope of information that can be accessed and widens the range of people who can access that information. In fact, as I've sought to explain, it makes no change to the circumstances in which information can be accessed. It will limit the range of agencies that can access information, and indeed by giving a specific definition of metadata, it makes quite specific what the obligations will be on the telecommunications companies and internet service providers. Now, a key issue is the cost of implementing these arrangements, because there are clearly costs that are incurred in storing data. The PricewaterhouseCoopers has been retained to look at this question, and evidence was provided to the committee regarding the conclusions drawn by PricewaterhouseCoopers, who concluded that the upfront capital cost across industry was going to be between $188 million and $319 million. And what the government has consistently said is that it will make a reasonable contribution to these costs, recognising, of course, that the industry participants are private sector companies and that there is a public policy purpose in imposing this data retention obligation. The government also acknowledges the reality that it takes time to put in place new IT systems and processes, and therefore the bill allows individual telecommunications companies and internet service providers to develop an implementation plan to allow a pathway to compliance over a period of up to 18 months. And that's very important, because what typically happens in telecommunications companies is that there is an annual IT upgrade cycle, and so this will allow the relevant information technology work to be accommodated within that annual IT upgrade cycle. So I conclude, Mr Deputy Speaker, by reiterating the point that what this bill is about, despite some of the confused commentary, what this bill is about is the imposition of a uniform period on telecommunications companies and internet service providers for which they must retain metadata, data which is already extensively retained, but the key issue is that the period for which that data is retained varies materially between different companies, and that there is an underlying public policy purpose in doing that, which is to ensure that the agencies and police are best equipped to do their work of seeking to maintain the security of Australians, a very important public policy purpose.
I thank the Parliamentary Secretary for his contribution. The question before the chair is that the amendment be agreed